Hi, Clark F. Harvey, the barbecue mortgage guy, owner of First Rate Mortgage. I've been serving clients for over 22 years in both residential and commercial lending in 5 states. And today we're going to talk about how we hold title and what the benefits are in the ways we can hold title. Today we have our guest, Chris Andrus. He is an attorney specializing in estate planning, bankruptcy, and commercial law. He has a bachelor's degree in molecular biology from Brigham Young University. He was published as an undergraduate for his research on cation selective cell membrane channels. He attended the S.J. Quinney College of Law at the University of Utah, graduated in 2003. He is a member of the Utah State Bar and the State Bar of Nevada. He enjoys helping families and business with their legal needs across the Wasatch Front. Outside the office, he enjoys all outdoor activities, and in his pre-COVID-19 life, he was a competitive West Coast swing dancer. I did not know that about you, Chris. That's awesome.
Now you know. Yeah. And that's it.
Awesome. I love it. And
it's difficult to social distance during COVID.
Yes. Yeah, there is that. There is the social distancing. So unfortunately, hopefully we'll all get through all this as a country together and stronger and better. Now, today's topic, I just want to state that it's for information and entertainment purposes only. This is not legal counsel. Consult your own attorney for legal advice. Thank you today, Chris, for joining us. If you could kind of touch on some of the topics of how we hold title, like sole ownership or joint tenancy, tenants in common, tenants in the entirety, or maybe in a trust and the benefits of that. If you can touch on some of those, that'd be great.
Sure. So when we talk about how real property is held in title, let me back up and just give a couple of fundamental tenets of real property ownership so that we understand how the law works, particularly here in most states in the United States. Real property is not something that we take with us. It's not something we ingest like food. It's not a personal property that you can put in your backpack or drive down the road. And so when we transfer rights in real property, what we're really doing is just that, transferring rights to the property. And legally, we often refer to them as the sticks in the bundle of rights. And sticks can mean different things. One stick could be the right to fence off your property so that nobody else comes onto it or trespasses against it. Another stick could be the right to improve upon the property, to build a house or some other building on the land itself. Another right could actually be the right of being able to transfer the ownership of all of the other rights to somebody else. And so that's what we call the sticks in the bundle of rights. These are the specific rights that you have in that particular real property. So when we transfer the real property, these rights are relative to what is being transferred. You can only transfer the sticks that you already have. You can't add sticks on that were never transferred to you. And that's the basics of the chain of title. When a title company goes and looks at your new property for title purposes or for refinance purposes, they will trace that chain of title all the way back to the sovereign, in this case to the country, not to a king or queen, in order to see where the origination was. The title company sometimes will accept things and make an exception in the title policy for things that do not match the chain of title. When you're transferring, most often people will transfer in one of 3 ways: a warranty deed, a quitclaim deed, or what we call a special warranty deed. What those have to do with is the sticks that are being transferred. So a warranty deed warrants marketability of title. In other words, you are warranting to the other person that all of these sticks can be transferred, that there's marketable title to the other person. A quitclaim deed is just the opposite. You're just giving the property to somebody else. They can take it, whatever is attached to the property, it goes with the deed. A special warranty deed is a hybrid. It's in between. There are certain things that are warranted and certain things that are not. So I just want to cover those basics real quick.
Awesome.
Yeah. So to get more fully into your question, when these transfers happen, how you hold title makes a difference. So if I'm married and I want to make sure, for instance, that if I pass away, my spouse enjoys all of those rights without having to do any other legal action, go to court or take any other action, then I'd want to hold that property with her as joint tenants. And usually we want to say joint tenants with rights of survivorship. That's a fundamental way to hold title. And how that works is the deed that is being transferred to you, the grantor will grant to, for instance, Chris and wife or Clark and wife, to those two as joint tenants with rights of survivorship. That way, if one of us passes away, the other one holds full title. That's the first, joint tenants. The second is tenants in common. Tenants in common is a way for multiple people to hold title to the property, but they are not joint tenants. In other words, they do not all own the whole property. They all own just a portion of the property. So if you have 3 tenants in common, each of them would own a 33% share in the property itself. There are no rights of survivorship. If one of them passes away, that person's estate takes that third, can sell it to somebody else. You can bifurcate the ownership, and you could end up with another tenant in common that you never anticipated to have in the first place. The last is tenants by the entirety. These are the 3 main ways. And tenants by the entirety is not always used like it used to be. There is an implication that a husband and wife in Utah who own property as in the entirety also means joint tenants with rights of survivorship. But it's not the same as putting on title joint tenants with rights of survivorship. And I had a case not too long ago where we had this very issue. Does the wife truly own the property outright as a survivor when it was deeded to husband and wife? That language was not in there, but they were married. And are they really joint tenants or not? If they're married, but it doesn't state husband and wife, tenants by the entirety. And so those are a few things you want to double check, in my opinion, when you are going through the title process. And I have seen, I wish I hadn't, but I have seen plenty of cases where it's just named husband and wife. And they meant for it to be joint tenants with rights of survivorship, but it was just called John and Jane, and that's it on the title. And then you can end up with potential issues, particularly when you go back to transfer the property to the person that you're selling to. So a few things you want to make sure of at the title company, that you own it the way that you want to have it owned.
Good counsel. That's, one of the things that we talk about, and it's real property is what you're talking about. It's not just homes. It's a vehicle is real property, or whatever else is real property.
Yeah, so a vehicle is still personal property, an automobile.
Well, there you go. Thank you, Chris.
Yeah, and so real property typically has to do with rights in land. That's how we define the difference between the real and personal property as a general rule. And it's those rights to the land that you can't take with you, so to speak,
Okay.
that makes it real property as opposed to personal property.
Awesome. And now there's some other, we talked about tenants in entirety, tenants in common. Like you said, they have maybe a percentage or portion, whatever that portion is, however you guys come to that agreement. And that's how it's recorded on title. And sole ownership, I've seen it like people, whether they hold title, whether they're unmarried male, or unmarried man, or unmarried woman, or married man, or married woman, or as, sole ownership, or whatever, joint tenancy, husband and wife, joint tenancy. I've seen
Correct.
Probably the most common.
Right.
What are some of the benefits of having it in a trust versus just having it as like joint tenancy, which is probably, I'd say 95% of the time, that people hold title, they just do it that way.
As joint tenants with rights of survivorship.
Right.
Okay. Yeah, so joint tenancy implies rights of survivorship, even when you don't say it on the deed itself. I always want to add it just to be clear. But what that means is that you each own an undivided whole in the property, but you hold it together. So if one person passes away, the survivor then owns the entire property outright. There's no bifurcation of the property as to ownership. So if husband passes away, if husband and wife are joint tenants with rights of survivorship, then if husband passes away, wife is sole owner. That would not happen with tenants in common. With tenants in common, the husband's share would go directly to his estate, and then however the estate disposes of the property is what the wife's new partner in the property, that's how she would end up. So when you're married and you want to make sure that your spouse is taken care of after you pass away, you always want it to be joint tenants. Circling back to what you had said about sometimes we say husband as a married man or husband as an unmarried or man as an unmarried man. Sometimes those are denoted in, particularly in community property states, where there is separate property between the husband and wife, and they want to let everybody in a community property state know, hey, this is my separate property. This is not part of the marital property.
Great information. Thank you. We're all learning, at least, you know, I've been doing this a long time, and there's always new things, different ways to do things. So what's the benefit of a trust, holding it in a trust?
I appreciate that. So a trust is a vehicle that we use. It's a separate entity, so to speak. I don't want to confuse this with an irrevocable trust that has its own social security number or things of that nature. We're talking about a revocable living trust most of the time. In a revocable living trust, you would put your real property in that trust so that the trust owns it and not you. The benefit of that is that you would not have to go through probate as to whatever property is within the trust itself. So let me back up just a second. There are three main people involved in the trust. There's a trustor or grantor, often used interchangeably. Then there's the trustee, and then there's the beneficiary or beneficiaries. The trustor is the person that creates the trust. The person that says, hey, I am going to take all of this property and it is going to be held in trust by the trustee. So the trustee has to do whatever I say the trustee needs to do within the trust document itself. And the trustee holds that in trust for the benefit of the beneficiaries.
Okay.
Right. And so often you'll see a trust state, husband and wife are trustors, they're the initial trustees. The trust is supposed to be administered for their benefit until such time as they pass away, and then it's administered or distributed to the beneficiaries.
Okay.
The advantage is that you avoid probate. You don't have to go to court and ask a judge to give you letters that say, hey, I'm allowed to dispose of the property. The trustee can already do that by virtue of the trust itself.
Okay. Okay. What are some, oh, go ahead.
Oh, I was just going to say probate, you know, every state does it just a little bit differently. If you're in Nevada, it could be 2 to 3 years before you get out of probate in some circumstances, right? Utah's a little bit faster. Typically, it's still going to be more expensive. It's going to take more time. It's not like, you know, dad left this car to the first son and this car to the first daughter, and then you can just give them to the son and daughter when you're going through probate. You have to get permission from the judge first, particularly if the estate is larger. If they're already in the trust, the trustee can just distribute those assets to the beneficiaries without any other court action or anything of that nature.
Okay. Any other benefits aside from those that you've mentioned, having it in a trust?
Well, that the avoidance of probate is by far and large the biggest benefit. There are other benefits, and there's several different types of trusts. For wealthy individuals who have a lot of assets and want to protect those, there are certain irrevocable trust vehicles that they can use in order to protect their assets against lawsuits and things of that nature. The other benefit of the trust, most of the revocable living trusts that I do, we add some clauses in for incapacity, so that the trustee can go ahead and operate the trust. If the trustor or the original trustee become incapacitated, successor trustee can step in. And nowadays, not to sound morbid, but I joke with my clients a little bit, right? A will is great if you die, but what happens if you become incapacitated? And so there are precautions that we take within the trust for incapacity. And more with advances in healthcare, we see incapacity, and we can have, for instance, I have a mother who had a stroke, and she lived for 12 years after the stroke. And so it was very important for us to have her assets in a trust and be able to administer those during the time of her incapacity. So it's probably important to note that I typically will not do a trust without doing a full estate plan. The estate plan has five components to it. It's the revocable living trust, a pour over will. I'll get to why we do the will in a minute. And then a durable power of attorney, advanced healthcare directive, sometimes called the living will in other states. And then if there are minor children, we do a guardianship, which is just an advisory opinion from the parents to the judge to say, hey, this is who I want to raise my children in case I were to pass away.
Okay, that makes sense. So it's basically the direction, really the difference between a will and a trust is it gives you more direction on incapacitation. Will just says this goes to here and here.
That is a large
for my version.
Yeah, and I apologize. Sometimes if we on a podcast, everyone's situation is unique,
right?
And so I'll have one client come to the office and they need X, and another client needs Y, just because of the differences in their family situation. So the trust avoids probate. The will does not. You have to probate a will. You have to go to court and get the will approved by the court. Utah has if it's done correctly, we have what's called a self-proving will, which basically means that it is automatically assumed to be valid. That's the gist of it, without getting into all the legalese.
Right.
And so it's easier to use that will, but I always do a pour over will within the entire estate plan. And what the pour over will does is it pours over all of the assets that were not in the trust. It pours them over into the trust upon death.
Okay.
And that way we still avoid some of the other issues that we would normally have in probate. This is a very important part. A lot of people end up with trusts, but they forget to fund them. And funding the trust is what gives you the benefits of the trust. If you have property, personal or real property, and you do not put them in the trust, the trustee cannot administer those things. They're not in the trust. They're still belonging to you personally, and those would end up getting administered through the will. So it's very important that you move all of your property into the trust. There are some exceptions, the things that you don't necessarily want to be placed into the trust. Usually those who have distinct beneficiaries of certain things, some deferred comp, some things of that nature. So you want to talk to an attorney. You want to make sure that you are getting good advice on how you organize the trust and the will. Funding the trust is why we do the pour over will as well, right? I mean, life goes on 10 years later, you haven't revised your trust, you haven't added your new property into the trust. So you do the pour over will to make sure that property then pours over into the trust.
Okay. So say there's somebody that, just bought their first house, or just maybe got a couple of kids, or maybe they don't have any kids at all, it's husband and wife, and or whatever that situation is, and they buy a house. When should they start looking at a trust? I mean, what are your thoughts there?
Right. It's a great question that is not often thought of. My younger clients fall into two camps. The I absolutely need it, and the I absolutely cannot afford it.
Right.
Usually one of those two. My feeling is that everybody needs it. Life changes. You don't know when or how it's going to change. And a trust, or this entire estate plan, is excellent spousal protection. That's what I call excellent family protection.
Right.
And sometimes, people don't always have my experience. They haven't seen the other end of things when there is no trust, or when there is ill-drafted documents and you're trying to fix what happened, which are the things that come across my desk. And so people don't always know, hey, this ounce of prevention is worth so much more down the road. But my feeling is that everybody needs it. The young couple comes in, they buy their first house, and they don't always understand that, hey, the house is likely to appreciate. And sometimes a lot more quickly than they realize. In particular here in Utah, if you had purchased a property 10 years ago, you could have $100,000 or $200,000 of equity just by now. And we're not talking a large home either. And so with that much equity, instead of having to probate it, if say the title is done incorrectly, it's not joint tenants, right?
Right.
If there's some other issue like that, you definitely want it in the trust. And what happens if both you and your spouse pass away? Well, you want to make sure that the trustee can immediately take care of those children. And that's one of the things that is a huge benefit of the trust. You don't have to wait for the guardianship to be approved. You don't have to wait for life insurance to come in. You can take the assets that are already in the trust and use those for the benefit of the beneficiaries. So a classic example would be, what if often my clients want the trust to be distributed to, say, their children at different ages, different amounts of different ages. They don't want all of the estate to go to the child at, say, age 18 or 21. So they'll make a third of it at 25, a third of it at 30, a third of it at 35. And in the meantime, the interest on the assets in the trust can be used for education or well-being, healthcare, things of that nature. Well, what if you have a child who is in college at the time, or just graduating from high school, making life plans, and something happens to you? Or what if you have younger children who you don't want to end up in limbo? I mean, they have needs as well, and health insurance or other issues like that. You want a trustee that has those assets available for the children that can act immediately.
That makes sense. That makes sense. No, that's good counsel. I appreciate that, Chris. And, because I have some adult kids that own homes and so forth. And so it'd probably be good counsel to say, hey, at least need to seek into it. And what's a great way to get a hold of you, Chris? If someone wanted to reach out, use your services, how can they best get a hold of you?
They can reach us as the law office of Chris L. Andrus. Our phone number is 801-810-7850. They can reach me directly by email. They're welcome to do that. I have a general email that is Chris Andrus, JD, CHRIS ANDRUS JD as in Juris Doctor @gmail.com. I give that one because it's easy for people to remember.
Okay.
And then I have more secure private email that I respond to people on once they become clients.
Awesome. That makes sense. And we'll post that up when we're done here. And thanks. Do you have any more comments before we wrap up, Chris? Any thoughts that you want to share?
Yeah, one last comment having to do with refinances and purchases and sales of real property. When you have, particularly for your business, right, Clark, when you have a couple comes in that has their real property in a trust, often the new lender, they're not going to lend to the trust, which is what the house belongs to at the time that they go to refinance or that they go to purchase or sell, I should say. And then, so what they will need to do is just do a quick deed that says, hey, we're transferring it back out of the trust into our personal names. And then once the refinance happens, then after you've received that deed, or once the purchase has happened, you receive that deed, then go ahead and just do another deed and put it into the trust. And it's not a big deal, but sometimes that people get confused, but it's vital. You want to make sure you do that. And it's just a lender requirement, has nothing to do with the trust at all.
Right. Yeah. Yeah, that's common. We in fact, we're dealing with one right now. Found out it's in a trust. We got the title back, so we got the trust papers. We'll be doing that as well. So.
Right. And most of the time, a lender that lenders are usually familiar with that. As long as it's a revocable living trust, they don't have an issue with it. If they do, call me. I'd be happy to call them and talk with the lender. When it's revocable living trust, it's all the same as far as the assets are concerned. And so the lenders typically don't have a problem with it. I think I've only had that once or twice in my career for a revocable trust.
Well, awesome. Well, Chris, thanks for taking some time to come on the show and share some of your knowledge and expertise. And you guys are welcome to reach out to Chris. We'll put the number and his email address and his website on there when we're done. And thanks again. Hope this is some value to all of you. And don't forget to like and subscribe to our YouTube channel, The Barbecue Mortgage Guy, and have a fantastic day.
Thank you, Clark.
You've been listening to Clark Harvey, the Barbecue Mortgage Guy. Clark is a licensed mortgage loan originator, NMLS number 240452, and his company, First Rate Mortgage, NMLS number 1172332. You can get a hold of Clark at area code 801-562-9100 or at his website at www.thebbqmortgageguy.com.